Welcome to Term Talk. I'm Clara Altman, Deputy Director of the Federal Judicial Center. In each episode of Term Talk, we discuss what lower courts need to know about some of the Supreme Court's most impactful decisions this term. Joining me today is Professor Laurie Levenson of Loyola Law School and Professor Evan Lee of University of California Law, San Francisco. Evan, Laurie, thanks for joining me. Today, we're going to talk about two cases. The first is Turkiye Halk Bankasi versus United States, a case that concerns the Foreign Sovereign Immunities Act. Then we'll turn to Pugin versus Garland. This is a case about the meaning of obstruction of justice in the context of the Immigration and Nationality Act's provision concerning removal. Let's start with the Turkiye case. Evan, can you explain the Foreign Sovereign Immunities Act and what aspects are at issue?
Sure. Until the 1950s, foreign sovereign immunity in American courts was a matter of common law. And then in the 1950s, courts began deferring to the State Department whenever a foreign state invoked sovereign immunity. Finally, in 1976, Congress enacted the Foreign Sovereign Immunity Act, or FSIA, which codified the rules governing when foreign sovereign immunity applies in federal courts.
So what aspects of the Foreign Sovereign Immunities Act were at issue in this case?
Well, in 2019, the United States indicted Halk Bank, in which Turkey owns a majority share, alleging that the bank conspired to evade U.S. sanctions against Iran, essentially through money laundering. Halk Bank moved to dismiss the indictment, arguing that it was immune from criminal prosecution under FSIA, and also that the court lacked subject matter jurisdiction under the General Federal Criminal Jurisdiction Statute, 18 U.S.C. 3231. The district court denied the motion to dismiss. The Second Circuit found that jurisdiction did exist under Section 3231. It further assumed, for the sake of argument, that FSIA generally provides immunity to instrumentalities of foreign states from criminal prosecution, but that FSIA does not immunize such entities from commercial activities or with regard to commercial activities, as was true in this case. The Supreme Court, per Justice Kavanaugh, found that the district court had proper jurisdiction, but held that FSIA only covers civil cases, not criminal cases. And then, importantly, the court remanded the case to the lower courts to investigate whether common law might provide sovereign immunity, even though FSIA does not.
So, Laurie, can you take us through the court's reasoning in this case?
Well, the court had to decide whether FSIA ever provides sovereign immunity in criminal cases at all. And then the court had to decide, well, what is the scope of this immunity in these criminal cases? That's why the case gets remanded down to the lower courts to see if, in fact, there is any immunity under common law. You know, the court finds that the FSIA does apply in civil and criminal cases, and at least when there's this commercial activities exception. But the concurrence, which is Justices Gorsuch and Alito, say you don't have to go beyond that, that in fact, common law principles should not be looked to here, even if we could figure them out, that was something that went back to the deference times of between the 1950s and 1970s, and trying to determine what is customary international law at this point is unclear, especially after Erie versus Tompkins.
So I want to turn to what the takeaways from this are for the lower courts, and I'll start with you, Evan.
Yeah, these disputes have been popping up in the context of suits brought for harm suffered by individuals due to the aid given to terrorists by foreign states. And I think the remand here is going to be really interesting. If the lower courts decide that some sort of common law did survive the enactment of FSIA, that potentially opens a pretty big box. And the Supreme Court would likely have to grant cert again somewhere downstream to shed light on what is in that box and what's not in that box.
I'm just curious what's going to happen if they do not find the immunity and what that will mean for foreign countries in assessing immunity regarding Americans in cases. So could have a dramatic impact both directions.
Sounds like this will be something important to watch. So I want to turn now to Pugin versus Garland. This is a case about the meaning of obstruction of justice in the context of immigration removal. Laurie, can you tell us more what this case was about?
This case is about the language relates to the obstruction of justice under the Immigration and Nationality Act. The issue is whether that language has to involve an essential element of an ongoing investigation or actual proceeding. The court decided in a 6-3 majority that the conviction underlying the deportation does not need to have that essential element. And this was actually a case that came to the court through two different cases. So the Supreme Court did resolve in favor of the Fourth Circuit approach, which gives broader ground to removability because that ongoing investigation is not required.
Evan, can you take us through the court's reasoning here?
Yeah, and in order to come up with a generic definition of obstruction of justice, the court looked to first the dictionary, said obstruction of justice in the dictionary does not require the existence of a pending investigation or judicial proceeding. The court then looked at the federal criminal code generally and noted that many offenses in Title 18 that are related to obstruction of justice, quote unquote, don't require existence of a pending investigation or judicial proceeding. The court then turned to the model penal code and said that its definition of obstruction of justice also doesn't require the existence of a pending investigation or judicial proceeding. And furthermore, Justice Kavanaugh stresses that the category that is involved here isn't just, quote unquote, obstruction of justice, it's related to obstruction of justice, which necessarily is a broader category.
So this case has a dissent written by Justice Sotomayor, joined by Justice Gorsuch and Justice Kagan. And I'm wondering if you could tell us, Evan, a little bit about what the dissent had to say.
They point back to the core federal obstruction of justice statute, which is 18 U.S.C. Section 1503. And they stress that this statute does require the pendency of an investigation or a judicial proceeding. The dissenters say that in its analysis of what constitutes core obstruction of justice, the majority is looking to statutes that are far beyond Section 1503 and its state analogs. And then after kind of casting its net far and wide, unsurprisingly finds that many of what the dissent refers to as these obstruction adjacent statutes don't require the pendency of an investigation or proceeding. So that's the criticism.
So, Evan, this concerns obstruction of justice in the context of the Immigration and Nationality Act, but based on what you've just described, I wonder if this applies outside of the Immigration and Nationality Act.
I would say the answer to that is going to depend on the specific application involved. So let's take Section 1503 itself. Clearly, this decision does not alter the definition of obstruction of justice within the meaning of 1503. But if the phrase related to obstruction of justice appears elsewhere in the immigration statute or appears elsewhere in the federal criminal code, then potentially, this case could change the interpretation of that phrase.
Laurie, what do you see as some of the takeaways here for the lower courts?
Well, in addition to what Evan has just explained, one thing that strikes me, Evan, is that this is not a categorical approach that the court is using. And so I'm wondering if they're moving away from the categorical approach on the convictions in just this area, the removability, or whether it could expand to other areas.
Yeah, Laurie, I would agree that longtime observers might say that this maybe involves a liberalization of the categorical approach. And so, you're left to ask if the court is moving away from the categorical approach in immigration cases, which would be a big change. It also likely would mean the end of the categorical approach in Armed Career Criminal Act cases, which would also be a massive change. But I want to stress that standing alone, this case, I think, does not come close to suggesting that the categorical approach is no longer the law.
Yeah, I agree with that, but it's just something to keep notice of, because it was, in this case, sort of an expansion of how to look at the underlying conviction.
Well, this will certainly be something to watch. Laurie, Evan, thank you both so much for joining us today.